right. Welcome back to Special Ed on Special Ed. Thank you for coming back and joining me today. Today, I am meeting with Meredith Braxton, one of my favorite special ed attorneys from Connecticut. Hello, Meredith. Thank you for joining me.
Good morning.
Good morning. We're going to discuss a case in which Meredith prevailed and discuss the components of a due process hearing or decision or pleading or all of that through this one case in which Meredith prevailed. But before we say one word, I'm going to play my disclaimer for you all.
The information in this podcast is provided for general informational and entertainment purposes only and may not reflect the current law in your jurisdiction at the time you are listening. Nothing in this episode creates an attorney-client relationship, nor is it legal advice. Do not act or refrain from acting on the basis of any information included in or accessible through this episode without seeking appropriate legal or other professional advice on the particular facts and circumstances at issue from a lawyer or service provider licensed in your state, country, or other appropriate licensing jurisdiction.
All right, Meredith. First of all, congratulations. This is awesome. You're welcome. This is a 54-page decision. There are 4 issues at the beginning that you raise, 176 findings of fact, about 46 conclusions of law, and at the very end, there are 9 orders. So that's a little overwhelming. And this is a final decision and order. And I'm a lawyer, and I was so excited when I got this, when we all heard that you had prevailed and we got to read it. And even I'm overwhelmed with 54 pages. So I want to start by, I want to read the actual issues that are listed in the decision. And then I want you to sort of tell us how we got here, if that works. Okay. So the 4 issues in the final decision and order are: has the board denied the student a free appropriate education, or a FAPE, for the previous 2 years by habitually failing to record the PPT decision in prior written notice? We're going to come back to that one. 2, does the current IEP and placement deny the student FAPE? 3, should the hearing officer place the student in a residential therapeutic school for students with CP or cerebral palsy, and, if necessary, order the board to hire an educational consultant to identify a placement for the student? And 4, is the student entitled to compensatory education, which would be education to make up for education missed? So those are some pretty loaded issues. Why don't you take us back to the beginning and tell us what happened?
First of all, this client is an amazing kid. And I actually spoke to her recently. She's really happy at May Institute right now. She's
great.
Really thrilled. So I'm really glad we got there. I was actually brought in after the case was pretty well set up. There was a lay advocate involved who did a really good job, got some amazing IEEs, independent educational evaluations from, some of the most qualified people I have ever run across. They were really super. She also has a super medical team, all of whom, even though some of them were out of state, they were totally willing to testify, and give me not very much time, but some time to educate the hearing officer about the student's conditions.
And that's an important component, is that there's a difference between what is a medical responsibility and an educational responsibility. And as you and I know, a lot of times those responsibilities overlap.
Correct.
Making it incredibly difficult to get anyone to provide them.
Yes. Yes. But these medical providers were very well able to connect what was going on with her medically to what was going on with her educationally. So
that's amazing.
They were really, really helpful. But when this case first came to me, I wanted to file for due process, but I was always, until the very end, I was always really concerned about the remedy, right?
Yeah.
Because you don't know which hearing officer you're going to get. And if you're not able to put a specific remedy out there, you just don't know where that hearing officer is going to go with it. So we had not found a placement for this student yet. She is very difficult to place because she has, high cognition, but her physical disabilities are profound and her communication difficulties are profound. So there's just not a lot of places, for that profile.
And that's an important piece too, understanding what you want. Because we run into that problem a lot with families where they know something's wrong, they know it's not working, but they don't know what will work or what they do want. And that makes it really, really hard for us because, and I explain this to clients a lot, you could go through a due process hearing and win on every single issue and not get the remedy you wanted, right? And I think the example I use is you could go into a hearing asking for an out-of-district placement, go through the entire hearing and have the hearing officer say, you are right. The school didn't do anything they should have done. But I think that school can create a program. So I'm going to order them to do that instead of residential. And now you've gone through the entire expense of winning a hearing.
Right.
And you're not getting any remedy. So that is a very concerning component that I don't think people realize.
And I really wasn't willing, I advised my client that I just didn't feel comfortable filing until we had better direction there.
Sure.
But as time went on, first of all, she was able to eke out a little money to find an ed consultant. And this ed consultant was really great. He was wonderful to work with. And I couldn't stand it anymore. I felt like Greenwich was torturing this kid, like literally torturing this kid, because, I was on the back end of every email and phone call, and what they were doing, I couldn't take it anymore. I couldn't take it anymore. So I was like, okay, we just have to file. We have to get this hearing going. And hopefully by the time we get to the end of the hearing, we will have a remedy in mind and we will have a placement. We almost got there, not quite, but it turned out okay. But that was a little bit of a risk that we took. But what was going on was so unacceptable that as a moral proposition,
right. And I think that's where school districts don't realize they really messed up is when they one of us off.
Yeah,
is when one of us is, even in the grand scheme of everything we've seen and experienced, if we get off, we're like a dog with a bone.
Yeah. Like, don't do this.
Don't get out of my way.
Yeah. That's how we sort of got to filing. The various issues that wound up being presented, we didn't even really address the FAPE based on not recording PPT decisions appropriately, even though they did not.
I was going to ask you about that because now in the new IEP, which I've yet to see, in case you're wondering, every school district I'm dealing with is like, yeah, we'll deal with that later.
I know.
Like, we've got to get back to school right now. So talk to me after Christmas.
Well, and what I'm hearing from them is it's taking them 6 hours to fill out the new form.
Exactly. This new convenient form that was going to take less time, but there's no prior written notice in it now.
But I thought the prior written notice was supposed to be a separate document, but I haven't seen one yet.
But we haven't seen any documents yet. So I think that this is a really interesting point about the prior written notice, because what that means in that issue, for those who don't understand, is that decisions were made in the IEP meeting that need to be documented in the IEP because they were either accepted or refused. And when a school district does that,
and the even more important piece of that is they're supposed to record why they did
right. Right. That's the even more important part.
And the data they relied on to get there, right? Mm-hmm. Which is usually how you can point out how freaking absurd their decision was.
Right, exactly. Because this is, my favorite is, I had one where they made the decision based on grades and performance, and the child had modified work and modified grades. So I was like, well, wait a second. Help me understand all of this.
My favorite is where they deny like a residential placement and they say it's based on the independent evaluation you gave them that recommended residential placement.
That's fabulous.
Yeah.
That's always, it's based on it because we read it and that's how we read it.
And we rejected all of it. So.
Yeah. So actually that leads me to my next question, which is, after you read the issues and the piece on why the hearing officer has jurisdiction, we get to your 176 findings of fact.
Yeah.
And so the findings of fact are sort of the meat and potatoes. Is that right? of the
Yeah, because
hearing.
I mean, you don't get to conclusions of law without those findings of fact.
They're the evaluation of your due process demand, right?
Yeah.
Your findings of fact are what
Yeah.
you base everything else on.
Yeah.
So how does the hearing officer determine what the findings of fact are? Like, do you provide those in your brief or your due process demand? Or how does the hearing officer come to determine which facts are actual facts?
So the post-hearing brief is always proposed findings of facts and conclusions of law. And, I can track through this decision the places where he definitely adopted, what I wrote in my brief. But there's a lot of it where he had his own thing going. And this particular hearing officer, who unfortunately has been picked off by Bertram Moses since then, he listened so carefully.
He works for Bertram Moses now?
Yeah, they hired him right after this case.
Sorry, I can't help but laugh.
I know, but it's so upsetting. It's so upsetting.
Speaking of absurd.
Yeah.
Anyway.
So he listened really carefully to all the witnesses and clearly was focusing on their credibility. And I could tell I was landing the punches, as I was going on, and he was getting them. And the one that was really telling was, there's a principle in examining witnesses for trial lawyers where, if you've got a hostile, first of all, he did go with the school district employees who I called on my case were hostile witnesses. So I was allowed to ask leading questions. Right.
Great.
So a lot of our hearing officers won't go there. Mm-hmm. And it makes it harder because you have to do direct examination with non-leading questions. Right. But anyway.
And so, for parents who don't understand that, right. I mean, that's getting a little in the weeds, but for parents who don't understand that, as attorneys, when we examine a witness, we are bound by certain restrictions. We can't just ask them anything. We can't just suddenly blurt out stuff, right? Like, we have to have a foundation. We have to lead them to a certain place. We have to have demonstrated certain things and have specific items and evidence. And there's a process. And if you don't go through the process, you don't get your information across. So one of the ways in which we ask questions is we ask leading questions all the time in our day, across the day. And you're not allowed to do that unless they're a hostile
Especially
witness.
with your children.
Especially with your children, right? We're trained to ask leading witnesses. That's why children shouldn't be witnesses, because you can lead them. So we really have to be cautious about that. And so then it depends on the hearing officer as to what they will allow. And they have a significant amount of leeway in what they will allow or not allow. So it sounds like this hearing officer was really focused, understanding the issues.
He really was. So one of the principles for examining a witness from the other side is if you land your point, you don't go on to ask like the ultimate question, because then that clues them in that they just messed up and they will go back and they'll fix it. You instead use that nugget in your argument later on. So that's right. How we roll. I got one of the school district witnesses to say that she made all the decisions in the PPTs. And so I'm sliding away from that because I'm like, hopefully her attorney didn't pick. Of course, her attorney picked up on that, but whatever.
Right. That's kind of a hard one to miss.
I'm going on to the next thing. And the hearing officer goes, whoa, back up. And then he starts questioning her and she doesn't fix it. She doubles down on it. And then on cross, her attorney tried to save her and she didn't go for it. So she basically got predetermination.
That's amazing.
Lack of parental participation. So the hearing officer in this case, he really listened and he was sort of going through issues in his own head, clearly. The whole thing about, in his findings of fact and his conclusions of law, he talked a lot about how the school district had the wrong primary disability for this child and that how it drove an inappropriate IEP. Now, you and I know that's actually true most of the time. If you have the wrong primary disability, it does to some extent derive, services.
Absolutely.
What schools always say is, no, we give whatever services are needed, no matter what the primary handicap is, blah, blah, blah. I felt like that was just a loser of an argument for me, like one I didn't want to spend a lot of time on. Right. I had so many other issues that I thought were really compelling and really important, and that would win the case. It was funny because he kept bringing it up during the hearing, and I was like, yeah. and I didn't really press it with witnesses, but he did. He would ask witnesses his own questions.
And I find that fascinating about hearings is that the hearing officer can and will just stop everything and be like, I have some follow-ups. I need you to clarify that.
Yeah.
I love it when we hear a hearing officer ask questions because all that says is, oh, they're listening. Yeah. They do get it because not all hearing officers really do get it. Not all of them have been doing what we do our whole lives. And we have to not only explain to them the process, the law, but the disability.
Right. Right. And this one is very low incidence. So it's particularly difficult to convey what it's like. Like I said, we had, especially her physiatrist was really great at describing what it was like to be, I'm allowed to use her name. She doesn't care. Sydney.
Okay.
So, what it was like to be Sydney. And that really got to the hearing officer. So did the videotapes of what was going on the bus ride.
Wow. How did you get those?
Well, they're an educational record. They're a FOIA record. And I was like a dog with a bone. And I did, when I filed, I also served an administrative code document request. And so at the very beginning of the hearing, when you're sort of like, what housekeeping items do you have? I'm like, I'm asking for these documents and these videos. They haven't given them to me. I can't do this hearing without it. And I got him to order them to be given to me. So
I find that I don't always get everything in a FERPA request. There's
never
a lot
get everything.
I know it's shocking, really. It's shocking, really. But in my FERPA request, I have a laundry list of things I would like included, and then I just hope I get most of it. But videos, and particularly bus videos, I think have to be the hardest things to obtain. That's just my experience. It's just a lot of red tape to get your hands on those videos. So that is huge. Yeah. So you provide your findings of fact. The board attorney is going to provide theirs.
Right.
So what the hearing officer chooses is going to be based on the testimony.
Right.
Right. And so that's your point in your testimony, is to demonstrate what actually happened.
Right.
I presume you had good witnesses and parents for this. Because I know for me, anytime I contemplate whether this is something that would go to due process or not, the first thing I think of is, who are my witnesses?
Yeah.
And my first thought is, can either parent be a witness? And that sometimes makes the decision,
Yes. I had one due process where, the hearing officer literally hated my client. And he was difficult. He was a difficult person. He was a difficult person to like. I liked him, but, I'm weird. But she ruled for us anyway. And I was a little, she even dropped a footnote about how she didn't believe him.
I love that.
So,
yeah.
Yeah. So it's very important. The parent is very important. Sometimes, like in this case, I had the parent, but as a backup, I also had her sister who had quit her job to help Sydney, during COVID, and had basically been in her life the whole time. So it was sort of a corroborating witness if I needed it, or it could be the primary witness about what was happening during remote instruction and stuff like that. So,
yeah. And I see you guys had 11 witnesses and the board only called 2, it looks like.
Yeah, because I called all her witnesses on my case.
So you called them all first so that you could get that done with?
In this particular school district, I find that the attorney, if you do this, if you call her witnesses on your case, she often hasn't glommed on to what their themes are and doesn't really prepare her witnesses well.
Got it.
So I can tell my story through them. And they're the people I had first. And the hearing officer had a little issue with it. He was like, aren't you going to call the mother? I'm like, I'll get there.
Yeah, well, because mom's usually number one, right?
Yeah, I don't like doing it like that.
Well, good. That's great. You should talk to my lawyer about that because she was working really, really hard to figure out how to not put me on the stand. Because for all of those parents out there who've heard you wouldn't be a good witness and took it personally and felt bad, I was informed I would be a horrible witness. So, and I'm an attorney who does this every day. So, don't feel bad about it. So you called everyone that you needed for your case, and the hearing officer allowed you to treat the school personnel as if they were hostile. So that is huge. It sounds like we got a really great hearing officer and then a board firm just snatched him up immediately.
They did. They did.
Yes. Funny how that works.
Happy about that.
Funny how that works. I wanted to touch on the time frame too, because you filed on October 12th in 2021, and your briefs were due in March 28th, 2022. And that is actually only 5 months. I was actually thinking for a hearing that went through so many witnesses that you would conclude this in only 5 months. I was kind of impressed.
And to tell you the truth, this included a month or two of me foot dragging.
Wow.
Because I was foot dragging because we didn't have that placement, right?
Right.
I was like, Brendan, come on, give me a school, right? So I delayed things a little bit, and then I decided I got to go. This has got to get going.
Right.
The hearing officer made it really clear that he was feeling pressure from the State Bureau of Special Education to move these hearings along faster. They're getting very concerned about their timeline issues, as they should.
As they should. Absolutely.
And he assured me, and I felt after we'd been going at this a little bit, I felt like I could believe him about this, that I could always just refer to an exhibit and he would read it. And I felt like he would. Right.
Okay.
So some hearing officers, you really have to have every single bit presented orally to them, or they won't focus on it. But in this case, I felt like I could rely on him to read the exhibits that were admitted. I sped through some of this stuff.
Yeah.
I mean, the medical people, I probably had an average 30 to 45 minutes with them, half of which I ceded to the other side. Right.
Wow.
Yeah. And so I was like, bang, bang, bang. I had one day when I had 6 witnesses. I blew through 6 witnesses.
That's insane.
I then laid down on the floor of my office and needed an IV of vodka, but
right.
It was intense, but it made the hearing officer very happy.
They do appreciate efficiency.
And I kind of liked it because I was able to get all the really important stuff in. And then the other side was kind of limited in what they could do with it, because they were also limited. In the end, I kind of liked it, even though I ordinarily wouldn't.
Yes, it worked for this matter. It worked for this matter.
And for this hearing officer, so much depends on the hearing officer you get and what their style is.
Yeah. And I hear that a lot from parents. Do you have experience with this district? Do you have experience with this lawyer? And all of those things do matter, but I feel like the experience matters more in knowing how to shift, because all those players change all the time. And I've had evaluators where I felt like I could just leave the room and they'd be fine. And then the next IEP meeting I go to with them, I'm like, who is this pod person? What did they do to my evaluator? So you just never know. There's a lot up in the air.
You don't know. And that's what I try to convey to my clients about due process. It's a high risk situation because you don't know which hearing officer you're going to get. You don't know what pressures they have on them because they are getting pressure from above. You don't really know how the evidence is going to come in. You don't know whether some of the board people who you think are charlatans are going to come across as believable. Mm-hmm. You don't know if you're going to be able to get in every document that you think you need to get in. I got a lot out of those board witnesses that had they been better prepared, I probably would not have. In this,
and that preparation is big. I mean, the prep is big for your clients too. I remember a colleague telling me, when you're talking about how is someone going to present, colleague was telling me they had a client and the school had really messed up, but this was an exceptionally wealthy client who came across as exceptionally wealthy when she walked in a room. And so she was asked to dial it down. So she walked into the hearing in her Keds and her blue jeans and a t-shirt and no jewelry. And the board almost dropped dead.
Really?
Because they were relying on this person to walk in and look like an extremely wealthy person and present the way she normally does, and hoping then that in and of itself would sway the hearing officer. But then she walked in and their philosophy was gone. Now, a good attorney doesn't rely on just that. Right. But to your point, people can present as anything when they walk in that door.
Yeah.
and they can say anything. So like if you have someone on the stand and they are flat out lying, what do you do?
Well, I mean, it depends on whether I have documentary evidence that I can confront them with that shows they're flat out lying. This is where a lot of times you do want to have at least partial transcripts of various meetings and recordings.
Yeah.
So they can't claim they said something other than what they did. And it's a problem because in my experience, almost, I would say 95% of board witnesses lie under oath.
Yeah.
And have no problem with it.
Yeah. And it's shocking sometimes to parents, right? And
absolutely. I mean, honestly, when I first started practicing law many, many, many moons ago, I was shocked. I assumed that everyone who was put under oath would tell the truth. And then I learned that actually a minority of people put under oath will tell the truth. It's not just in special education law.
Yeah.
It's not just board witnesses. It's pretty rampant.
It's pretty rampant. And I do think that people have a different level of respect being under oath. I do believe that as a rule. And I do think that anxiety is heightened in the person when they are lying under oath versus just in a school meeting. I absolutely can see that. I can see the change in their body language from lying in the IEP meeting to lying on the stand. They're way more uncomfortable, but that's another reason why I like going to the IEP meetings, because they may be more comfortable there, but you do get a sense of who you can trip up and who you can't. And if the school has a bad witness, you make sure they know that.
Also, why I prefer due process hearings to be in person, because if you've got that body language going on the other side, you can start drilling into it and sort of push them completely out of their comfort zone.
Yes. And that's more difficult on the screen.
Yeah. Oh, it's impossible.
Have you done any hearings on the screen?
Well, this one was completely virtual.
Oh, this one was virtual?
Yeah.
I don't think I realized that. Maybe I must have. I mean, maybe just because it's so normal now that I didn't think of it. So that must have been really hard then. I didn't even realize this was virtual.
Yeah, it was very hard.
That's
really hard.
Amazing. Your experience is you would still prefer in person, right?
Yeah, for that very reason. Just looking through the screen at someone, you can't hold their eyes. You can't sort of judge their expression. You can't figure out how to destroy them. That's
right. You can't pick them apart to the degree that you would like to.
Yeah. So bad, So when you're a litigator, you just have to admit that you have a dysfunctional personality, right?
Yes.
So
that's why we do this, right?
Yes, exactly. We get paid for being like completely not the social norm. So
I always say that I do that. I'm a lawyer because I think this way. I don't think this way because I'm a lawyer.
Right,
it's just the only place that I fit in. So let's talk a little bit about the remedies, because from the remedy in the decision, it doesn't look like you ever found that one place. Did you?
Well, no, we found it afterwards.
Okay.
So May Institute was one of the ones that our ed consultant found that he thought was the leading candidate. Ironically, also the neuropsychologist who did an independent evaluation had put that out as a recommendation as well. So I was able to direct the hearing officer to an email from him saying, this would be a good place. And also, ironically, that particular neuropsychologist, I wasn't in love with his evaluation. And I was very concerned about him as a witness because I've actually seen him under oath before. And so I elected not to call him.
Interesting.
Yeah.
That's a risk.
Huge risk.
Right? Because, the first thing you're going to hear from any attorney is you want to go to a hearing, you need an expert.
Yeah. Well, but we had all these other experts
but that's usually the one that we want, right? It's the neuropsych.
Fortunately, he had spoken to that entire medical team and incorporated what they said in evaluation itself. And then all of those medical experts wrote follow-up letters saying, we agree with that neuropsychologist. This is what she needs. So I called every one of those medical experts.
Got it.
And that's how I got and this is what happens in a due process hearing. Like, I had him on my witness list in case I had to put him on. as things develop, you have to make decisions about what you're going to do and what's the hole in your case. Then I was like, oh, one of the holes in my case is what's the remedy? And I don't usually call educational consultants, but I did with this one. Also because he's got lots of bona fides, right? He's run a therapeutic school. He's been,
he's got credentials that you can defend.
Yeah. Mm-hmm.
Yeah, so, I love that when I get stuff from parents who say, this is the expert. And I'm like, well, no. They don't have any credentials. No one's ever heard of them. They're in a different country. I don't know that I'm going to get anyone on board.
He worked really hard for this placement. I mean, beyond what he ever has to do with anyone. I was on a low fee on this case. He did a low fee on this case. So we sort of felt like, okay, we're going to do
You're in it together.
Yeah. And
invested.
And one of the things we got as a remedy was that he got paid his full fee.
Oh, good. Yes. So that's what I was going to ask you about was the remedies, because one of the remedies is when you win a hearing is that you're entitled to your legal fees.
Right.
So what I'm curious about is when you submit that legal fees bill, what is that going to look like after 11 witnesses and 5 months?
It was close to 100,000. It was like 98,000. There were a few things.
And a ton of parents listening to this just passed out.
Yeah, but that's what I tell my clients. It's between 50 and 100,000 for your average due process case.
Yep.
And on top of that, you may have to be paying experts, and that's not reimbursable.
Right.
So
that you're not going to get back, and that I can't risk, but we can always risk our fees.
Right.
Because we can try and get them back. So that does give you more skin in the game, I guess.
Mm-hmm. They pushed back on a couple of things. One of them is definitely legitimate. I put it in there and hope it would just slip by, but it didn't,
Right.
And then there were a couple that were like, arguable, right?
Right.
So I just rolled over on those because I'd rather get it paid, right?
Yes.
And so I wound up being reimbursed $92,000.
Mm-hmm. Well, and I mean, I always say it's the only civil right that we negotiate. So parents are always negotiating away their rights. And we as attorneys are always negotiating away our fees.
Yeah.
We do nothing on the parent side but negotiate against ourselves from the beginning. I don't know of very many, if any, attorneys who've gone through a full hearing and actually received their full fees. They just don't. I also find it when sometimes I hear people say, oh, well, litigation fees are so much more than, I'm like, we're never seeing those. So, calm down, take it down a notch. Yeah, I found the remedies really interesting because the one remedy said to find the placement, and a consultant is ordered if you can't find a placement. So the hearing officer did order that consultant as well, correct?
Yep, absolutely. And the thing with May Institute is they are not going to accept anyone unless they're fully funded, right? Because it's a very expensive placement.
Yes.
So the day this decision came out, the ed consultant got on the phone with them with 2 words, fully funded. And within a week, we had an acceptance. But they had to do a little bit of hiring to bring her on. So she started right after Labor Day.
Right. And I think that's important too for parents to understand that not every placement is ready to take your child that day. They're usually, an acceptance usually means that they can prepare to do that. So if you come, they will then start preparing. They're not going to staff for a student who's not there yet. That's very typical. And that's great. So now, is this child going to be there for
she's placed there now.
Yeah. So it's her stay
put and everything else. I don't see them after that horrendous decision.
Yes.
Coming back and saying, no, you're ready to come back to Greenwich.
Right. And school districts have done that. They have a year after a hearing decision said, well, we gave it a year and now they're all ready and everything's back together. But you have that hearing decision under your belt. And that is something you can pull out and use. And it would be foolish to do that at this stage. And particularly given how many fights are going on between parents and school districts. There was a time where fighting every hearing decision was worth their time and energy. I don't think it is anymore.
Yeah. But then, so there was a significant amount of time between when the decision came out and when she was able to go. In the meantime, he ordered remedies for while she was still in the Greenwich school system. And I actually had to get down the state's throat to get them to enforce this decision.
Really?
I did.
What happened?
They were ordered to have an aide in the home for 30 minutes before the ride to school to help the mom get her ready. And they just didn't do it. And I had to go to the state, and they eventually got to saying, Greenwich, get your act together, and do it. And they finally did it. It made a huge difference. Then she was supposed to have a medical taxi instead of the bus that was so torturous for her. Never got that. I was on the state's case like every 2 days.
Mm-hmm.
And Greenwich kept giving them a spreadsheet showing all the contacts they made to try to arrange a medical taxi. And I was like, this is just baloney. I mean, there was one point where they were like, okay, well, the legal director, Mike McKeon, and Mary Jean Chabrol, who unfortunately was the person assigned to the enforcement part of this, the retired.
She's retired, isn't she?
Yeah, except she's still a part-time consultant for some things. I'm like, why did you assign this to a part-time retired consultant?
This is pretty significant. Yeah.
So at one point they were like, well, we're going to be on the phone with Greenwich about this on Monday, and we'll let you know. And I'm like, I want to be on that phone call, but I'm on vacation. And they're like, I'm like, do it on Friday when I'm not on vacation.
Mm-hmm.
No, oh, well, we can talk to you Friday and then we'll talk to them on Monday. I'm like, no, I will just be on this call during my vacation. So I'm hiking in Maine and losing the signal every 3 seconds. And I am yelling my butt off. And my husband's like, oh my God. And I keep losing the signal, I'm dialing back in angrily. And on top, so because anyway, never got the medical taxi, even though I'm busting a gut. And on top of that, in between, when I started getting down on their case and this phone call, they had finally posted this decision. I got it via email, but then they post all of their decisions, right? And the decisions are written so that there's no identifying information. The student is called student, parents are called parents, etc. But it identifies the witnesses, aside from the parent, and the school district and all that. Well, they put this one up, and they've blacked out everything that would identify the school district or the school district witnesses. And I was like, okay, so while I'm on the phone screaming, I'm like, who did this? Which one of you did this? What are you doing? They're like, oh, we thought it might be too specific and, have identifying information. I'm like, if that was your concern, you would have called me or the parent to ask if we had a problem with it, but you didn't. So it seems to me that you were just trying to not embarrass Greenwich, which should be completely embarrassed about how they treat.
Well, exactly. My dog's going nuts. No, that's exactly what I was going to say, which is that, that seems like protecting the district where.
It was absolutely. And in the meantime, I'd gotten a written consent from my clients saying you can put it up on redacted. I was like, I have that. And they put it up on redacted after that. But,
seen that before, though, that the school district personnel and school are redacted. Is that a thing?
No. If you look on every single other decision, there's not a single redaction. Not one.
So who decided to do that?
Mary Jean Chabrol. She admitted it.
Did she say why?
Because she was afraid it would identify the child.
That's a lie.
I think so.
I feel like that's a lie. But that sounds interesting. Well, and it really is frustrating because I always feel like when people say, oh, but these poor teachers and, it's not really their job.
I don't care.
I feel like I'm with you on that. And I feel as a former teacher and a former administrator, admittedly, I spent about 10 minutes in each role, but I didn't have a problem being honest in the meeting. Now, that was me. And right. Perhaps I didn't have as much at risk as some people by doing that. And I respect and understand that. But I go nuts when parents say, well, the teacher told me this, but they won't say it in the meeting. And I always say, well, then I don't trust that teacher.
No,
I just don't. It's great you're getting inside intel, but how do you know they aren't turning around and saying the same thing to the district about you?
Exactly.
And they're just protecting their butts.
Yeah. If they're not willing to say it in the meeting, it's useless.
It's absolutely useless. You can see it when people are scripted in the meetings. You can tell. And look, it's not my intention to embarrass anyone. But if you have made a conscious decision to toe the party line, then you are making a conscious decision to take the consequences of that action.
This child's speech and language pathologist basically said that she agreed to include oral motor goals to help Sydney learn how to talk, which she could do, right?
Mm-hmm.
Basically as a favor.
Oh, as an accommodation to the parent?
Yeah, because she wanted to talk, but she didn't really need it for accessing the general education.
No, why do you need language for that, Meredith? I know. I'm sorry. I just get flip. I can't stop myself. I love that when it's as an accommodation.
I'm going to call out that. I'm going to call that speech pathologist out on that.
Yep.
It's
not an accommodation. It's what the child needs.
Yeah.
And, if that, I found that frustrating during the pandemic too, when people were like, well, I don't want to be on tape or on screen or what have you. And I do understand that there is something to being under a microscope and people taking things out of context. We've all had that happen to us at some point on the internet, right? Or in a text, something has been taken in the wrong tone. And I just feel like, haven't we all been using the internet long enough that we should know that?
Yeah.
And, the tone gets lost and things get lost in translation. But knowing what happens and being able to reflect on that and make changes, that's important. If we're not willing to do that, and that's where I feel like we are right now in schools. I feel like no one's willing to reflect.
Yeah.
Because everyone's so afraid, even more so than before, to look back and say, yeah, we messed up. And I understand because there are legal ramifications to saying that. So I get why they're not announcing it to the world.
Yeah.
But maybe their inside voice, like in the back of their head, maybe could say, we screwed up and we got to fix this.
Honestly, I find that the better board attorneys manage that, right?
Yes.
By having a good relationship with you, giving you a call, saying, can we talk about some solutions?
Right.
It doesn't have to be an explicit, we messed up. It can be we're willing to make it better, right?
Right.
Good board attorneys manage that.
Right. And some board attorneys, when the parent calls you, I'll say, you know what? I know we can get X, Y, and Z, which will help bring everyone back to the table and start the conversation over. And then there's some board attorneys where I have to say, look, I hate to tell you this, but we're going to start off fighting because that's where you are. And that's unfair too. It depends on who represents your district as to what access you will have to that due process and whether you will be able to fight them or not. And not every parent has access to us.
No.
And I was just talking to Christine Lai on my last episode about SELF and the Special Legal Fund and how they've allowed for so much access for parents who couldn't afford it. Regardless, look at this. This is like I said, you had 11 witnesses. It took 5 months. This took up a significant amount of your time, most of which you were not paid for at the time. Like that's something else people have to realize. We get paid when we work, right? Yeah. Like I'm not on a salary over here with fabulous benefits.
We eat what we kill, as they say.
Exactly. We eat what we kill.
Yeah. So, I had restricted cash flow for a few months there because it took a huge time.
It takes a tremendous amount of time for us to have even one full-blown.
And I was like, if I win, I'll be fine. If I don't, I'm going to be stuck in wind for a little bit, So,
exactly. Yeah. So, it's tough all the way around. And you have to have the bandwidth to do it. And you have to not be afraid of creating bad law because you have to look at, if I lose this, the way that I have asked this question, if I lose it, what will that do to other families?
Exactly. And this decision, I felt like I got more good law out of this than I even expected.
So tell us what you think the main takeaways are that you got from this decision that you think are solidified, that are helpful for parents.
Well, the blasting of how the school district treated COVID and learning during COVID.
Yes.
And the failure to implement the IEP at all, really, during COVID. And he runs through
that was huge
on the legal side, the support for you were supposed to do what you needed to do and you didn't do it. That leads to comp ed. So I thought that was good. I thought the way he treated the requirement for residential placement when there were mixed issues because here we had mental health issues, but also medical issues. But those medical issues were very much intertwined with ability to be educated.
Yes.
Right. So the way he merged those things in talking about the requirement for residential placement and the board's duty for that residential placement, I thought that was very helpful.
Yeah.
So those were the two takeaways that I really enjoyed.
Yeah. No, those were great. And those were great for the rest of us. Thank you. That's why I say thank you so much.
And the comp ed piece too.
The comp ed piece is great.
Yeah. So that was good because he talked about how you don't need a gross violation to get comp ed if you're not in an aged out situation.
Right.
And he kind of blasted the whole equities argument, which I was like, I didn't even understand the board's argument. I'm like, this isn't a unilateral placement case.
Right.
This third prong about the equities, right?
Yes.
So, but he turned that around to, well, maybe it's, relevant to comp ed.
Well, and that's, to explain to parents who don't understand really what we're talking about, because legalese going. No, it's good. It's good because what that means is there are specific arguments we have to meet. So the first question I have to ask is, did the school district provide an appropriate program? And if the answer to that is yes, then nothing else matters, right? So there are different prongs of these different arguments, and some of them get to the point of equity, and this one doesn't. So it was unclear where he was going when he went down that road, but what he was doing was taking that equity argument and putting it towards compensatory education and saying that for these reasons, this child does require compensatory education, which is meant to bring the child back up to where they would have been had they had that service. So that's a big win, especially post-COVID, where that's a lot of the arguments is whether it's compensatory or not. So that's a tough argument. And so that was a great win for parents.
Yeah.
The last thing I want to ask you about, though, is the quotes throughout the decision, because I started reading and I thought, was this a quote from the transcript? So at the beginning of every section, the hearing officer wrote a little quote and the chapter and pages that it was from. So I put that into my trusty Google search and discovered that he was quoting Helen Keller throughout the whole thing. Can you talk a little about that?
You could have looked at the footnotes.
Or I could have looked at the footnotes. That would have required this dyslexic woman to look at every footnote in this 54-page decision.
Okay. He won't do that to you. He basically took I guess it was the autobiography of Helen Keller and took various quotes. This kid touched his heart, and she has touched mine as well. She wants to start a school for kids with disabilities. She's an amazing kid. Yeah. Right before she went to May, I went and had dinner with her, and she finally had the new communication device that had actually been recommended and that Greenwich never did.
Wow.
And we sat and had a really long, pretty fluent conversation about how did we get to the point where she gets to go to May? What was the hearing like? Who did I call? What did they say? Do I have to go back to Greenwich Public Schools for the 3 days of school they have before I go to May? No, you don't. I can see her really doing something in the world. Her physiatrist testified very clearly that he expects big things from her. And the hearing officer clearly felt that this child had a lot of potential and could make some change in the world. I think putting in those quotes helped bring it to we need to liberate this kid from the confines of her body, right? Yes. And let her be the person she can be. So I just about cried when I was reading through the decision with those quotes sprinkled throughout. I talked to a board lawyer afterwards, and she was like, well, that was quite a decision. I'm like, yeah, it was. And she's like, the quotes from Helen Keller were a little bit of overkill. I'm like, does ice run through your veins?
Right. And by the way, not if you were there. If you were there, these fit in perfectly. And I did read a couple of the footnotes, Meredith, but I liked how he did talk about, while this student is not deaf and blind, they are bound by these disabilities in a way that we can't comprehend.
Yeah.
And that it wasn't until, Helen Keller, somebody taught her how to communicate, that she was able to share herself with the world, and that those comparisons he felt applied to this student as well. And I think that just added to the impact of those quotes. Yeah. And you're right. You could tell that this was a very emotional matter. And this is one of those matters where you read through it and you think, well, it's a slam dunk, right? You read this and you're like, of course you're going to win. But that just simply isn't how special education works.
And back to what we were talking about at the beginning, you can win and the remedy can wind up being useless.
Exactly.
So
there's a lot of risks, but it's decisions like this that are the reason why we continue to do it and move forward, and also make sure that your attorney moving forward in a hearing has the experience and background necessary to, and resources. If you don't have experience, you can get experience, right? You can learn, you can get experience, you can get mentored, you can do all those things, but you can't pretend you know what you don't know.
Right.
And it's important to make sure that your attorney does practice special education law, that is their primary, that they are not doing something else and are not distracted by other laws that may conflict with the IDEA, which people don't realize. There are a lot of educational rules and laws that actually conflict with the IDEA. So if you're more familiar with those than the IDEA, then you may not be giving the right advice.
It's ironic that a law that was passed in order to be parent-friendly and increase parental participation in the educations of disabled kids is so non-parent friendly.
It's not parent friendly. It's not free to access.
No.
Because if you want to access it, you need an attorney or an advocate, and those are not free. Just think about the professional development that parents do just to understand how to talk to their attorneys. To their school districts, just to get the vocabulary to advocate for their child. They spend a tremendous amount of money on professional development and all of those pieces. So
to back up for a second, the other thing I thought this decision was great on was LRE, least restrictive environment.
Oh, yes. Talk about LRE for a second.
So least restrictive environment means that your disabled children are supposed to be educated to the maximum extent possible with non-disabled kids. My argument here was because they were screwing up so much, and they really did not include her appropriately in general education things. She was isolated from her peers. And it's even as much as like the chair they were using. They were having her in a wheelchair in her classroom, which separated her and put her at a different level than her peers. And the physical therapist...
Do you mean physically, like height-wise?
Yeah. So she's not even at the table, right?
Oh my God.
And they were like, the IEEs were like, you need to get this kind of chair and put her here so that she's with her peers. And they never did any of that. It was stuff like that. And then she would have total meltdowns, especially if she had an accident or whatever, and be removed from the classroom because of her meltdowns, and then be removed to go to the bathroom and spend all sorts of time on it there. The general education setting for her was more restrictive than one that was designed for kids with similar disabilities. And he went for that argument, which I really appreciated.
And that's an amazing argument. And I make it all the time. It's right. I call my philosophical argument of what's least restrictive, right? And I had a student once who we were arguing over Villa Maria. And in the public school, the student had to be in the substantially separate room all day, including lunch, including everything. But at Villa Maria, they could roam the halls. They could have lunch with their peers.
And from my perspective, that is absolutely an LRE argument in favor of Villa Maria.
Exactly. Yeah. Exactly. And so, fortunately that didn't have to go to a hearing at that point in time, because I don't know where that would have landed. But I do think we are getting closer to understanding that may be a less restrictive environment for that student. It looks restrictive to us.
But if they have no peers to relate to, right?
Exactly.
And they're not being educated with the same materials, if they're sitting in the general education classroom, everyone else is working on, XYZ, but they're working on at a different level, on a different skill, on their own little worksheet with their para right here. That's not a least restrictive environment for that child.
No,
they're other, they are separated.
Right. They're substantially separate from everybody else, even if you physically sit them in the room. And kids do not learn independence through osmosis.
No.
It's not by sitting near typically developing children that you become typically developing. The goal is to become independent.
Right.
And what does this child need to become independent? And sometimes what a child needs to become independent is more children like them.
Right. Right. So I thought that his ruling on that issue was helpful for this argument.
Yes. Yes, that's very helpful for this argument because it gives us a little something with some meat on it.
Yeah.
To argue.
Yeah. When I was bringing it up, you could see him going like, that's an interesting point, Yeah.
And now I really hate Virgin Moses for taking him out of the hearing officer pool.
Upset.
Come on.
And, he was previously, I think he was in a judge advocate corps.
Okay.
He was a JAG. And you could tell, he had plenty of litigation experience, right?
Okay.
So it was sort of easy that way for me because my litigation arguments made it in a place where he understood them.
Right.
So that was good.
Good.
And now he's gone.
And so this is it. This is his swan song, which we will have framed up in many offices around Connecticut. This was incredibly helpful, Meredith. And thank you so much for coming on and talking to me about it. I don't think parents really understand everything that goes into due process. They just hear fight the school district. I will put the link to your decision in my show notes. So anyone who wants to geek out like the rest of us do. The unredacted
one, right?
Yes, the unredacted one. So you can see everybody's name and all the footnotes. And you could just click on them and they pop up. So I'll put the link to that there. But if someone's listening and they're like, wow, I need to hire Meredith, clearly, because she's the only attorney who can understand me and my child, how do they reach you? How do they find you?
Well, it would be great if I had a website, but I just haven't over the last 20 years had the time to put one.
You haven't really had a need, huh?
Not really. I'm going to do it soon, though. I swear.
Okay. I have a good name for you.
I've had it in process for a long time. You can look me up on the internet, probably. I don't know.
I'll put a link to how you can find Meredith.
Yeah. Sometimes when you put in Meredith Braxton, there's some Meredith Braxton on some soap opera or something.
That's awesome. Mm-hmm. So you show up as a soap opera star?
Yeah. Yeah.
I think that's great.
Yeah. No, it's the name of a character, I think.
Oh, it's the name of the character.
Yeah. Mm-hmm.
Even better.
Yeah.
All right. I will put a link to Meredith in the show notes as well. If you feel you must reach out to Meredith and find her. And thank you so much, Meredith, for coming on and talking to us and talking about your case. And thank you for taking it all the way. Because I think that is not easy for any of us to do. And,
I had not had a case go all the way in like 2 years. So I was also sort of chomping at the bit.
Yeah.
Because I am a litigator at heart. And I like to go to hearing occasionally. And I was like, it was sort of killing me.
Yeah.
So I was happy to bring it all the way. And I got a few more going into the can this week that I think at least one of them might go all the way.
That would be amazing.
Yeah.
Well, thank you. And that it makes a huge difference for the rest of us. And it definitely helps all of us, when we take these.
I was about as pleased as one could be with that decision.
I know. It's amazing.
Even better than I had hoped.
And that's amazing. And the family must have just been beside themselves.
Oh, and Sydney, she's happy as a clam at May.
I'm so happy. And validation that it wasn't her, right?
Yeah. Oh, but she always knew that.
Yeah. She's smarter than they are.
She is. She really is.
That's often the problem. Well, Thank you so much, Meredith.
Thank you so much for joining me today. Please don't forget to follow this podcast so you don't miss any new episodes and leave a review when you have a chance. If there's anything you want to hear about or comment on, please go to my Facebook page, Special Ed on Special Ed, and find me there. I'll see you next time here on Special Ed on Special Ed. Have a fabulous day. The views expressed in this episode are those of the speakers at the time of the recording and do not necessarily reflect the official policy or position of any other agency, organization, employer, or company, or even that individual today.